Welcome. The Massachusetts Appeals Court is pleased to present this educational video to help explain the Informal Brief Pilot Program. When a party brings an appeal to the appeals court on its panel docket, that person is called the appellant. An appellant must file with the court a document called a brief. After an appellant files a brief, the other party, known as the appellee, may file a response brief. To make sure the appeals process remains accessible to everyone, the Chief Justice of the Appeals Court has authorized this Informal Brief Pilot Program. In this video, we will help you answer the following questions. What is a brief and what is an informal brief? What is an informal record appendix, and do I have to file one? What should I include in my informal brief? What happens next? Where can I find more resources? Please note that the appeals court does not provide legal advice, and this video is not a substitute for legal advice. If you have questions or need legal assistance, please consult an attorney. A brief is the written argument you file in the appeals court to help the judges understand the case and your arguments about the appeal. Your brief explains the issues or questions the appeals judges must decide, what happened in the trial court, the facts of the case, and, if you are the appellant, why the trial court's outcome was incorrect and should be changed, or, if you are the appellee, why the trial court's outcome was correct and should not be changed. If you are the appellant, the person filing the appeal, you must file a brief and a record appendix, or your appeal will be dismissed. The appeals court accepts two types of briefs. First, a formal brief which must substantially comply with the Massachusetts Rules of Appellate Procedure. These rules include some format and content requirements that people representing themselves on appeal can find difficult to follow. Second is an informal brief, which must follow the appeals court's informal brief guidance but omits some sections of a formal brief, such as the table of contents and table of authorities. The goal of an informal brief is to make it easier for a self-represented party to present your case without getting confused or overwhelmed by complex procedural and formatting rules. Most self-represented parties file informal briefs. If you wish to submit an informal brief, you must use the informal brief forms and follow the guidance provided on the appeals court website. The first step is to determine if your case qualifies for the program. You may file an informal brief if you are representing yourself without a lawyer, and your appeal is currently entered in the appeals court on its panel docket, which means you have a case in the appeals court and there is a P in your docket number. If your docket number has a J, then it is a single justice case and it is not part of the informal brief program. The second step is to go to the appeals court informal brief pilot program webpage to download and review the forms and resources. This webpage includes forms for an informal appellant, appellee, and appellant reply brief, forms for an informal record appendix and an impounded record appendix, guidance on how to complete and file your informal brief and record appendix, sample informal briefs and a sample table of contents to the record appendix, and other helpful resources. The third step is to read the entire informal brief guidance carefully. The guidance provides important information such as what to include in your brief and record appendix, how to handle impounded information, how to determine the due date of your brief, how to file your brief and appendix, and how to determine who must receive a copy of your brief and appendix. The fourth step is to organize your materials from the trial court and to prepare your record appendix. The fifth step is to type out your brief. As this video will discuss, your brief must include citations to the record appendix and citations to legal authorities. You may file your brief after your case is entered in the appeals court and you have received the appeals court's notice of entry of appeal. From the entry date, you have 40 days to gather copies of the lower court documents and organize them into a record appendix, to research and to write your brief, and to serve and file your brief. You may ask the appeals court for more time to write, serve, and file your brief by filing a motion to extend the time to file your brief before the due date of your brief. You must serve this motion to all other parties. But, before you file a motion, if you are the appellant, be sure you have filed the docketing statement in the appeals court. Each appellant must file a docketing statement within 14 days after receiving the notice of entry of the appeal. The court will not allow any extensions of time to file your brief until you have filed the docketing statement. The docketing statement form is available for download on the appeals court website. An appeal can be dismissed for failure to comply with the appeals court's filing deadline, so be sure to stay on top of it and ask for more time if you need it. The Suffolk University Law School Legal and Innovation Technology Lab has a form on their website that you can use to prepare and file a motion to extend the due date of your brief with the appeals court. Please visit the website, courtformsonline.org, and select Enlarge Time to File, Appeals Court, then complete the online questions to create a motion. Your motion must tell the court why you need more time, how much extra time you are asking for, and why giving you extra time will not hurt any other party's rights. As the due date cannot be extended for more than a total of 120 days, many parties ask for an extension of 60 days, or whatever amount of time you need. The appellant must serve and file an informal record appendix, which is a separate document from the brief and includes copies of important documents from your case that were filed in the trial court or agency. The informal record appendix must have consecutive page numbers starting with the cover page as page 1. Your informal record appendix must include copies of the trial court or agency docket sheet, the pleadings, such as a complaint and answer, the motions, oppositions or responses, and memoranda related to your issues and legal arguments in your appeal, the orders, rulings, or judgment you are appealing, the exhibits, the transcript of any evidentiary hearing or trial, and the notice of appeal. In addition, you may include other documents from the trial court record that are related to the legal issues and arguments, but you may not introduce new evidence. Please note that all impounded documents must be placed in a separate volume of the record appendix that is clearly labeled as an impounded record appendix. It must contain its own table of contents and be paginated. The appellee is not required to file a supplemental record appendix but may file one if the appellee's brief cites to documents or testimony that were not included in the appellant's record appendix or transcripts. If the appellant files an informal brief and appendix, the appellee may file a supplemental record appendix with any missing documents that should have been included in the appellant's record appendix. However, if the appellant filed a formal brief and appendix, the appellee must file a motion asking the appeals court for permission to file a supplemental appendix. The appellee's supplemental record appendix is always limited to materials that were part of the trial court or agency record, and no new evidence may be included. The court's forms include all the sections you must complete in an informal brief. You need to include a cover page, which includes the appeals court docket number, the parties' names, the title of the document, and the filer's name and contact information. A statement of issues or claims of error section that states the issues you want the appeals court to review. A case history section stating what happened in the trial court. A statement of the facts section that states all of the important facts related to the issues you are appealing, with citations to the record appendix where proof of those facts can be found. A legal argument section stating your legal arguments, as supported by citations to legal authorities such as case decisions, statutes, and court rules. A conclusion or relief requested section stating the action or outcome you are asking the appeals court to take in its decision, and a certificate of service confirming that you provided a copy of your brief and record appendix to the other parties. This video will discuss each section in more detail. Although an informal brief is not bound by all the rules for a formal brief, there are still some important rules to keep in mind. Your brief must be typed and double-spaced. You must use a monospaced font such as Courier New. The font size must be 12-point or larger. You must number all the pages of your brief consecutively, such as pages 1 through page 30, and your brief, including the cover page, must be 30 pages or less. The cover page is the first page of your informal brief and must be numbered as page 1. As demonstrated in this slide, it must have the full appeals court docket number, which has AP in the middle, the case name, including the entire name of each party, such as Susan Smith versus James Jones. Please note, whoever was the plaintiff in the trial court is listed first, before the versus. The title of the brief, that identifies the filer's name in the document, such as informal brief of the appellant, Susan Smith, and, at the bottom, the filer includes their name, mailing address, phone number, and email address. You can find your case information on any documents you received from the appeals court in your case. The next slides contain samples of a cover page. Sample 1 shows the different parts of the cover page. Sample 2 shows a sample cover page. The Issues on Appeal, or Claims of Error, section is where the appellant must provide clear and concise statements of the legal issues, or claims of error, you would like the appeals court to decide. Provide a short statement for each issue stating how the trial court or agency decided on that issue and why you believe it was wrong or needs to be changed. The next slides contain samples of statement of issues. For example, the issues in Sample 1 are: did the trial court judge make a mistake in ruling that the contract was not valid because there was no agreement on price? Did the trial judge make a mistake in calculating my income for child support? Did the Zoning Board of Appeals exceed its authority by granting the special permit? The examples in Sample 2 are: was the jury wrong to find me liable for trespass because there was not enough evidence to prove it? Was the judge wrong to instruct the jury to ignore my defense of necessity? Was the jury wrong to find me liable for conversion of property because there was not enough evidence to prove it? A citation is a reference that directs the reader to the specific page or pages in your record appendix or transcript that support the facts of you stated. Your brief must contain a citation to the record appendix or transcript for each statement of fact you include. Parties can use abbreviations such as RAP to mean Record Appendix Page or TRP for Transcript Page. You must include the specific pages where the judges can find the information you reference. For example, defendant received a letter from the department on June 18, 2024. RA page 5. Defendant told plaintiff that there was an agreement. Transcript, pages 34 to 35. Defendant made an offer to pay $150 per month in child support. RA page 3. It is your responsibility to include the record appendix citations. If you do not include them, it will be more difficult for the appeals court judges to find support for what you say happened. The case history section contains a paragraph or two that explains what happened in the trial court or agency. First, briefly describe the nature of your case, such as a personal injury or breach of contract case. Next, provide an explanation of what happened in the trial court or agency. Specify the orders, decisions, or judgment you are appealing, the dates they were entered, and the name of the judges who made the rulings. The next slides contain samples of a case history. For example, Sample 1 contains sample facts with fictitious parties and events for demonstration purposes, and states, this case involves a child support dispute where I, the plaintiff, asked the court to establish child support for our minor children. Record Appendix, RA, page 3, on July 8, 2024, the Probate and Family Court Judge, Smith, J., held a hearing and reviewed the defendant's financial statement. Impounded RA pages 2 to 8, the judge ordered defendant to pay child support of $400 per week. RA page 17, a judgment was entered on July 31, 2024, RA page 20, on August 5, 2024, the defendant filed a notice of appeal. RA page 49, Sample 2 contains sample facts with fictitious parties and events for demonstration purposes, and states. On January 5, 2024, Papa Bear filed a civil complaint in the Norfolk Superior Court against me, Goldilocks, for trespass and infliction of emotional distress. Record Appendix, RA, page 20. A jury trial was held on August 12, 2024, before Judge Wolf. RA page 80. The jury returned a verdict for the plaintiff and awarded him $60,000 in damages. RA page 80, the judge entered a final judgment on August 31, 2024. RA page 90. On September 20, 2024, I filed a notice of appeal. RA page 100. The Statement of Facts section must contain detailed explanation of the key facts in your case related to your issues in the appeal. For each fact you include, you must provide a citation to the record appendix page or pages that shows the appeals court judges where they can find and confirm the facts in the record appendix. Keep in mind that you cannot introduce new facts or evidence on appeal. The next slides contain samples of statement of facts with citations to the record appendix. Sample 1 contains sample facts with fictitious parties and events for demonstration purposes, and states. On March 19, 2024, at approximately 2 p.m., a black Honda Pilot driven by Fred Flintstone was traveling southbound on Minot Street in Dorchester, Massachusetts. RA page 4, at the intersection of Minot Street and Gallivan Boulevard, Flint's vehicle struck a blue Hyundai Elantra driven by Barney Rubble, which was traveling eastbound on Gallivan. RA page 5, the collision caused minor damage to both vehicles. RA pages 8 to 10, Exhibits 2 and 3, the intersection was controlled by a traffic signal. RA page 25 and Exhibit 5, Flintstone testified his light was yellow at Minot Street. Transcript page 65, Rubble testified his light was green on Gallivan. Transcript p. 95, and neither driver saw the other car until they collided. Transcript pages 70 and 99. Sample 2 contains sample facts with fictitious parties and events for demonstration purposes, and states, Papa Bear testified that he lives with his wife and cub, Mama Bear and Baby Bear, in the Blue Hills Forest dividing Quincy, Massachusetts, from Milton, Massachusetts. Papa Bear testimony, Transcript Volume 1, page 20, on October 10, 2023, the three bears went for a walk to let their porridge cool, locking the front door behind them. Transcript, page 22, when they came back, they found their porridge eaten, a chair broken, feathers all over their beds, and a stranger, Goldilocks, sound asleep in Baby Bear's bed. Transcript p. 80-85. The legal argument is an important section of your brief. Here, you need to explain why you think the lower court or agency made a mistake or the decision should be changed by the appeals court. You must connect your case's facts to the law to support your arguments. Be sure to include citations to the record appendix for the facts and also include citations to legal authorities that support your arguments. It is your responsibility to verify that all your citations are correct. Please be aware that while artificial intelligence may be helpful for legal research, you should not rely on it when researching legal authorities for your case. Artificial intelligence will sometimes make up court decisions, quotations, and laws that do not actually exist. To support your legal argument, you must include citations to Massachusetts or federal legal authorities such as the Massachusetts General Laws, which are known as statutes or laws, regulations, and court rules. Published decisions of the Massachusetts Supreme Judicial Court and Appeals Court. For example, if you are arguing that the trial judge applied the wrong law to your case, you can cite to a decision of the Massachusetts Appeals Court that supports your argument and cite to the specific law that you believe should have been applied by the trial judge. Remember, you must connect your legal arguments to the facts of your case. The next slides contain samples of legal arguments with citations to legal authorities and the record appendix. For example, Sample 1 contains a sample argument with fictitious citations for demonstration purposes, and states, "The judge abused her discretion in calculating my income for child support purposes, resulting in an amount that is too high by $550. See Rabbit v. Tortoise, 50 Mass. App. CT. 600-605, 2015, decision to modify child support is reviewed for abuse of discretion. The judge should have subtracted the costs of my phone, internet service, car, and Airbnb stays from my income, RAP. 75 to 90, because those were ordinary and necessary expenses required to run my business and do not count as income under the Massachusetts Child Support Guidelines Section 1C, 2023. See Bear v. Raccoon, 331 Mass. 333, 338, 1940. Sample 2 contains a sample argument with fictitious citations for demonstration purposes, and states, "To prove conversion, a person must have wrongfully taken, used, or destroyed another's property." Town v. Village, 10 Mass. 100, 102, 1813. Here, I ate some porridge because I was starving to death, accidentally broke a chair in the process, fluffed a few pillows, and took a short nap in a bed. Transcript pages 76 to 86, Exhibit 1, RA page 4. These minor actions don't count as wrongfully taking or destroying property. The chair was fixed the next day, transcript page 93, Exhibit 2, RA page 4, and the bears still had 2 other chairs, bowls of porridge, pillows, and beds that they could use. Just like in Captain Hook v. Crocodile, 417 Mass. 269, 270, 1982, where the plaintiff had more clocks in another hand. Here, the bears were not deprived of anything. The conclusion is a short statement that states the action or relief you are requesting the appeals court to take when it decides the appeal. For example, you may ask the court to affirm or uphold the outcome in the trial court, reverse or vacate the outcome in the trial court, which includes ordering different relief than the outcome in the trial court, or remand the case back to the trial court for more proceedings including a new trial. The next slides contain samples of conclusions. For example, Sample 1 states, "I ask this court to reverse the dismissal of my complaint." Sample 2 states, "I ask the appeals court to reverse the Superior Court's judgment that I am liable for trespass." The appeals court should either decide in my favor or send the case back for a new trial. The certificate of service is a signed statement you must fill out. It states that you have provided a copy of your brief and record appendix, or any other document you are filing with the court, to all attorneys and any other self-represented party in your case. It must include the name of every attorney or self-represented party who will receive the documents. Whether you are sending the copies by electronic filing or by regular mail, the recipient's email or physical addresses, and the date you sent them. At the bottom of the certificate, include your signature, typed name, physical address, phone number, email address, and the date. An informal brief must be filed with the appeals court clerk's office. You can file your brief electronically, which is known as e-filing. To e-file, you need to: first, save your documents as PDFs. Second, go to www.efilema.com and create an account. Third, upload your brief and record appendix as PDFs into your appeals court case, and serve a copy of your brief and appendix PDFs to all other parties through eFileMA. The appeals court's website has helpful instructions and explanations about how to use eFileMA. In the alternative, you can also file a paper copy of your brief and serve paper copies by mail. After the appellant has served and filed their brief and record appendix, the appellee may file their own brief in response. An appellee who is self-represented can file an informal brief, using the form on the appeals court's website. An appellee has 30 days from the date when the appellant served their brief to file the appellee's brief. An extra 3 days is added if the appellant served the brief by mail or electronically, for a total of 33 days. An appellee may file a motion to extend the due date, as discussed earlier. The courtformsonline.org website has a motion to extend the due date form. The appeals court will review the parties' briefs. Several months after the appellee has filed their brief, the appeals court will notify the parties of the 3 judges who are assigned to your case. The judges may schedule a hearing with the parties, called an oral argument, or they may decide the appeal based on the briefs, with no oral argument. The court will notify you when your case moves to this phase. The 3-judge panel usually issues its decision within 130 days after the panel begins reviewing your case. Once the decision is issued, the court will send you a copy of the decision. In addition, the decision will be posted on the Supreme Judicial Court Reporter of Decisions website for public access. If you need to find more resources to help you prepare your informal brief and record appendix, the Massachusetts Trial Court Law Library's website provides extensive legal resources, including resources to help you understand and create legal citations. The Social Law Library website provides a list of sources for accessing free legal materials in Massachusetts. The appeals court website has briefs that were filed in past cases and in cases currently scheduled for oral argument. The court's website also includes sample informal briefs and the informal brief forms. The appeals court hopes you found this video helpful in preparing your informal brief.